Good evening, our Patriot family, and welcome to another episode of the Fight for Patriotism, where we talk about the Constitution and how we can understand how to fix this country. On tonight's episode, we will be discussing Articles 2 and 3 and how they affect us in this government. I'm your producer, host, and brother Zachary Smouse, and with me is your brother Angry Conservative. I'll open up with a Bible verse, play my introduction, and then check on how our brother is. The Bible verse for Thursday, June 16, 2022 is, "Those who belong to Christ Jesus have crucified the flesh with its passions and desires." Galatians 5:24 NIV.
We need you now. We need you now. One day, one day, one day, I hope you see the truth. This puppet show stays on because of you. We've been dancing with the devil way too long. I know it's fun, but get ready to pay your dues. Oh God, come back home. This crazy world is filled with liars and abusers. We need you now before we're too far gone. I hope one day they finally see the truth. God, we need you now.
How's it going today, Angry? And how's my family and chat doing?
Everything with me is going good, Mr. Mouse. And I hope everything down in that chat room is doing, everyone down there is doing good, because it's been a few days since I've been on a stream with anybody. But yes, today's been a good day. Little hot, but good day. And how are you doing, Zach? While Zach's typing up, I do got a question for the people down in chat. Do you know what Article 2 and 3 actually deal with?
New song, he's having electricity issues right now.
Yeah. Because he's out in Cali, isn't he? I thought he was in Cali.
Oregon.
All right. Yeah. They're all over that way. But everyone in chat, what is Article 2 pertain to, and what is Article 3 pertain to in the United States Constitution? I want to see if anyone actually knows. Because, Zach, I know we know it, but I want to see if anyone down. Tom, you're a good man. I love that you actually have the Constitution right there in front of you, my friend. Now that Tom is a smart man. This is why I like doing this. We got some smart people, and but yes, I got a little pocket hand. I got a little one that Zach's bringing out. I have one of those too. And I will put this in chat. I will give you my website. If you don't actually have a Constitution and you'd like to download it, you can actually go to my website and actually get the Constitution for free. Download it for free. There you guys go. Remove that. But yes, that's what we have. That is the Article 3 provides for a Supreme Court. Article 2 is the executive branch, or as most of us consider that one, the President of the United States. That's what them two articles are all about. But I hope Zach's doing all right, because we do need him. Hey, Ron. Hey, Ronnie. 1 minute. All right. But yes, I will read a couple of things on the articles. Article 2 explains the executive branch, the branch of the government known as the executive branch. The executive branch is pretty much, how can I say? The executive branch is like the CEO of the country. Yeah. He runs it. He runs the United States on a daily basis. He doesn't have to actually go to the board. He can actually do it himself. He is the head of the military, but he can't declare war. Article 3 is the judicial branch, the federal court system. So that goes from the Supreme Court all the way down to the appellate courts all over the country, which there are 13 appellate court judges. Thank you, Tom, for putting the printable version. Zach, do I even want to know what the heck you're laughing about over there? Come on.
Sorry guys, my dad was doing a turd.
Oh, for crying out loud. That is just... But, Zach, are we ready for that first video?
This is Kim from Khan Academy, and today I'm learning more about Article 3 of the...
Zach, you got the wrong one.
Hi, this is Kim from Khan Academy, and today I'm investigating Article 2 of the Constitution, which establishes the executive branch of government. It's Article 2 that establishes the office of the President of the United States, tells us who's eligible for that role, how they get elected, and what powers they have. Now, today, it seems very natural to us that the executive branch of the US government should be led by a president, but at the time of the founding, it wasn't at all certain that that would be the case. After all, the founders had just rebelled against a monarchy where power was placed in the hands of one individual. They'd been so nervous about executive power that the first governmental system of the United States, the Articles of Confederation, didn't have an executive branch at all. So to learn more about Article 2, I sought out the help of some experts. Professor ▴ᖏᑍ is an expert in the separation of powers, particularly executive powers, and teaches constitutional law, foreign relations law, and presidential powers at the University of Virginia School of Law. For more on the debate about what an executive branch should look like, I talked to Professor Michael Gerhardt. He's a leading constitutional scholar whose specialties include civil rights, civil liberties, and separation of powers. So, Professor Prakash, why did the framers choose to invest power in a president? Were there any other options for an executive branch?
They thought about creating an executive council, which would have been composed of 3 or more executives that would have jointly exercised whatever executive power they vested in the executive. And so you might have had like a triumvirate, like they had in Rome, or an executive council, like they had in some states. And they also thought about doing something slightly different, which is to have a single president, but then require the president to go to a separate executive council before he made several important decisions. But in the end, they decided we like to concentrate executive authority in the hands of one person, thinking that that would be better for law execution, better for assigning responsibility. It would bring energy to the executive branch, and the executive branch wouldn't be riven with dissent and dissension.
I asked Professor Gerhardt how long it took the framers to decide on the form the executive branch would take.
It was something on which the framers came to an agreement pretty quickly. They came into Philadelphia, and almost at the very outset, there was a proposal that came forward from Virginia, part of the Virginia plan. And the Virginia plan proposed a single executive who would serve for 7 years and not be eligible for re-election. The delegates would eventually agree on certain features which are now encapsulated or can be found in Article 2.
I think one of the tensions we see in the Constitution and the Bill of Rights is trying to create a structure for government that's strong enough to do what it needs to do, but also one that doesn't have too much power so that it doesn't become a tyranny, as the framers had seen in Europe. So were they nervous about having an executive branch in the first place?
That's a great question, Kim. We had a confederation before the Constitution. It was called the Articles of Confederation. And in that system, we had Congress acting as a plural executive. And Congress and its observers of Congress thought that Congress wasn't really well suited to playing the role of executive, to supervising foreign affairs and supervising executive officers, both military and civilian. And so by the eve of the Philadelphia Convention, where they wrote the Constitution, there were quite a few people saying we need to have a separate executive. We need to invigorate it with authority, because if we do that, we will then have a successful new government under the new Constitution.
Alexander Hamilton, for example, wanted an executive who basically served for life. He didn't get it. You can imagine that for many delegates, an executive who could serve for life would sound an awful lot like a king. And that's exactly what they had just rebelled against.
Other people said, if you create a unitary executive, if you create the single executive, chief executive, you're going to have a monarchy. You're going to have someone who is intent upon seizing powers of various sorts, who's going to, want to install maybe a hereditary monarchy somehow. And that was the tension between those who wanted to have a stronger executive, a stronger single executive, thinking that that would be the best thing for the government, and those who thought that, a single executive would descend into a monarchy.
So I imagine it was pretty tricky for the framers to think how they could have an executive branch that was powerful enough to get things done, but not so powerful that it took on that tyrannical cast that they were really eager to avoid. So what powers did the president eventually end up having?
The president's made commander-in-chief of the Army and the Navy. He has the power to pardon.
The president has the authority to nominate people to certain high-ranking offices subject to the advice and consent of the Senate. Among those offices are included Supreme Court justices. The president has the authority to be able to negotiate treaties.
So he's got a host of authorities. And then there's the central question that's disputed, Kim, which is, does the first sentence of Article 2, which says the executive power shall be vested in the President of the United States, does that also give the president any authority beyond what's listed in Article 2, Sections 2 and 3? So, for instance, does the vesting clause of Article 2 give the president authority over law execution? Right? Is he able to direct the execution of federal laws by subordinate executive officers? Does the president have the power to remove executive officers by virtue of the vesting clause? And then significantly, does he have foreign affairs authorities by virtue of the vesting clause to speak to other nations, to direct U.S. ambassadors, etc.? And that's a dispute that's been ongoing for 200 years, whether the vesting clause really grants additional authorities to the president.
So all those different powers we now more or less take for granted that are common to U.S. presidents are all set forth, for the most part, expressed in the Constitution. There are a few implicit powers the president will take on over time.
As I understand it, the president's powers have grown fairly significantly over time. Do you think the framers would be surprised by how much power the president has today?
Yes, it's grown, I think, to be perhaps more powerful than many of the framers initially thought it might be. There were some authorities, for example, the power to remove people in the executive branch that are not spelled out explicitly in the Constitution. Over time, the presidency would acquire that power, and ultimately the Supreme Court of the United States would ratify that or affirm that authority. That's one big area, removal power over executive branch officials, that gets clarified and sharpened over time.
Over time, the president and his assistants have cited the vesting clause as a source of a great amount of authority. And some of those claims you might think are consistent with the Constitution, and others you might think are inconsistent. So what are the things that presidents have claimed? They've claimed the authority to direct the execution of federal statutes. I think that's consistent with the original design. They've claimed some limited authority over foreign affairs. I think that too is consistent with the original design. They've also claimed authority to exercise certain powers in emergencies. That's more contested and more debatable, whether they have some sort of emergency power, either temporary or otherwise.
When Abraham Lincoln comes into power, Congress is not in session, and Lincoln's got to respond in real time to an invasion on federal territory and to try to begin the protection of the United States. And he does that initially without Congress being a part of it, because he has to move very quickly.
They've also claimed the authority to wage war. And that's also contested because, of course, Congress has the power to declare war. And many people believe that that text means that Congress gets to decide whether to wage war. Modern presidents take the position, or often take the position, that they can use military force overseas without getting a declaration of war, or more precisely, without getting congressional approval for the use of force overseas. So yes, the president's powers have changed over time, and that's a source of deep controversy.
So what checks can the executive branch use on the legislative or judicial branches of government?
Kim, the executive has a veto, and the veto permits the president to reject legislation sent to his desk by Congress. So under the Constitution, Congress has to present all legislation to the president, and he can either sign it and thereby make it law, or he can veto it. And if he vetoes it and he sends back his objections to Congress, they then have the option of overriding the veto by a 2/3 vote in both chambers. And so the veto gives the president great leverage over Congress, because they know that if he vehemently opposes a particular piece of legislation, they can only pass it if there are rather sizable supermajorities in both chambers.
He has a power to be able to pardon people for federal offenses. So again, that's a unique presidential authority. The presidency, in a sense, has taken more of the limelight away from Congress, which might be making the law, but administering the law is going to require a lot more time and put the president in the position of also exercising discretion over how to enforce the law. So that becomes another important authority of the presidency. How do you go about enforcing it? What kind of discretion do you have when you do enforce it?
He also has the power to recommend measures to them under the Constitution. That is to say, he can suggest that they pass legislation on a particular subject, thereby making sort of a vague suggestion, or he can actually present them a bill and say, I'd like you to consider this. They don't have to act on the bill, but he has that authority. And, he can also tell them about the State of the Union, right? That's the State of the Union clause. So those are the checks he sort of has on Congress. And those are significant checks, right? The members of Congress don't get paid unless the president signs the bill that passes the appropriation for them, or they override his veto. So those are significant checks. And then with respect to the judiciary, Tim, there aren't as many checks in the Constitution. The Constitution never says that the executive branch
I wonder if anyone caught what I caught. Zach, maybe you caught it? Did you hear what they actually said? Nothing happened, Miguel. I just thought I would throw something out there. In that presentation, how does Congress get paid? What has to happen? Nope. Congress, if the president doesn't sign it, Congress doesn't get paid. I wonder if we could get somebody in that office to really make them take a decrease in the money they get for a year for their service. That would be an interesting thing to do, wouldn't it, Zach? That would be interesting to actually have a guy stand up to Congress and say, you either you take less or you don't get paid. But I thought I would point that one out because I have seen this video before and I forgot to tell you that I wanted to stop it there. But the president has the power to not pay Congress. That's an interesting.
I do that because they shouldn't be having careers in politics.
That I agree with that. I don't think they should. But first time's statement up. And he's right. Because it goes right back into the hands of the members of Congress. Actually, it goes back into the hands of the political establishment. I think it honestly has gone into certain presidents' pockets, but that's a whole nother story. I'm not going to get in on that one. Let's continue with Article 2, and because there are a lot of interesting facts in this.
To execute judgments issued by the courts. But that's been our practice, and I think it's an implicit feature of the Constitution that when courts issue judgments, the executive will honor them and enforce them. Because that's an implicit feature of the Constitution, presidents don't really have much leverage over the courts, right? Because the president does get to nominate them and does get to appoint them, and that gives him some sort of say over who becomes a judge. But once they're judges, he doesn't have any say over what they decide, and he typically, as I said, enforces their judgment. So the check on the judiciary is who gets into the federal courts, who gets to serve as a federal judge. Once they're judges, the president doesn't have the same kind of check that he has on Congress. There's no veto on judicial decisions, for instance.
The president can unilaterally or on his own issue what are called executive orders, which are essentially mandates that govern the operations within the executive branch. One president can set the priorities one way, but another president can reshape them a different way.
Interesting, because executive orders can do very positive things, like Truman's executive order that the armed services be integrated, but they can also do very negative things, for example, interning Japanese Americans during World War II.
That is correct. And so the executive orders oftentimes might reflect a particular president's values, but again, also particular president's priorities. The challenge with an executive order is that it only lasts longer than a particular president's term if other presidents are willing to sign off on them as well. And so, for example, you can see how President Trump has decided not to continue certain executive orders that President Obama put into place, just as President Obama chose not to extend certain executive orders President George W. Bush put into place.
Lots of rules and laws are not made by Congress in the modern era. They're made by executive and independent agencies. And so, a lot of the rules that we have to follow about the environment or about labor or about, securities, they come from agencies and not directly from Congress. And when the agency is an executive agency, the president not only appoints the people that run that agency, the president or his assistants in the White House are often involved in crafting the rules and shaping the rules in various ways. And so, if we think the mass of rules and legislation comes from the government, the executive, and not the Congress, then the president has a great role in that.
So our first president was George Washington. In what ways did Washington set important precedents that are still with us today?
There are a lot of people, a lot of scholars who think that things would have been quite different had it not been Washington. And the fact that George Washington would become the first president helped put a lot of people at ease, because he was widely viewed as trustworthy and somebody who wouldn't be naturally disposed to become tyrannical. And Washington himself understood from the very outset of his administration that nearly everything he did would create a precedent for other presidents to follow. And so Washington ends up becoming quite influential, not just in helping define things, but also in reassuring people that this system can get off the ground and the presidency wouldn't necessarily be a tyrannical office, and that the president, in fact, could be an effective part of a new government.
If Washington's not there and they can't see an honest man taking over as president, you might very well have had an executive council. They might have been wary of who would be a unitary executive and wanted to have a plural executive in order to make sure that no one person became too powerful. And another way of thinking about this is, if you create a new constitution in the wake of President Nixon, you're going to have a different constitution because people are more distrustful of executive authority. If you have a new constitution after a really honest and noble and successful presidency, people are going to write an Article 2, an executive article that's more favorable to the president. And the situation for Washington couldn't have been more favorable. They had seen the problems with weak execution under the articles and in the states. They thought that weak executives were a problem. They saw this person.
Then why didn't we have this when Obama ran?
Because I honestly think because of how the powers of the president have actually changed since the time from George Washington in the late 1700s until Obama in the at the beginning of pretty much the teens. From '08 until 2016. I think that over time, the executive branch has gotten more powerful with executive orders and everything else. So that things have changed over time. That's why it didn't happen under Obama. But that's a good question, Zach.
Could be a strong executive and be a responsible and wise executive, and those two things conspired to create an executive that was one of the most powerful in the world.
So Washington is trying to signal, look, we don't want to create tyrants here. We're not kings. We're not presidents for life. We'll serve at most for a couple terms, and then we will willingly lay down our authority and let other people follow us. That's actually a critical precedent that, again, every president until Franklin Roosevelt follows. And it's one that reflects Washington's special values, that the most important office ultimately is not the office of the presidency. It's actually the office, so to speak, the position of being a citizen of this country.
So we've learned that, thanks to the example set by George Washington, the framers of the Constitution felt confident that they could invest power in a president to have an energetic executive branch. But as Cy Prakash noted, the framers might be surprised at the way the president's powers have grown over time, through executive orders and the use of military force. However, Michael Gerhardt brings up an important point, that in the United States, the president is first and foremost a citizen, not a ruler. To learn more about Article 2, visit the National Constitution Center's Interactive Constitution and Khan Academy's resources on U.S. government and politics.
But I got a question for you, Zach. Do you think if we would have a person like George Washington today, that the powers of the executive branch would be what they are? Now, that is a... Because I honestly think we have let the executive branch get more powerful because of how many how many federal departments there actually are. Think about this. We got the FBI, the CIA, the NSA, the EPA. All of these three-letter agencies are under the executive. They're underneath the president. Every single one of them. Because I honestly think but I also think the framers would be a little upset at us that we have made politicians as a career. So that's just my opinion.
Our founding fathers would be boiling their blood over what government has become.
That's very true. That's very true. But this is why I love doing this stream with you, because we can throw that idea out there. So Article 3 has to do with the federal court system. Because, Zach, I got one for you. Since we're going over we're doing the three branches. We already did the legislative, which is Congress. We already did the executive. Now we're about to do the judicial. Which one do you think is the most powerful out of the three? And I'll even ask that one to the chat. Which branch of government do you think is actually the most powerful out of the three of them? But yeah, that is the question I have for everyone in chat.
I'd say judicial because they can overrule laws and stuff.
Most people would think that, but the only thing the Supreme Court and the appellate courts can actually determine is if a law is constitutional. So the appellate courts, not the state courts, but the appellate federal courts can only determine if a law is constitutional. And Tom is right. Tom is very much right. No branch is supposed to be more powerful than the others. Because think about this, Zach. What did we just learn with that video? That the president appoints someone to the federal court. So, with the help of the Senate. So, what's that tell you? No branch is actually more powerful than the other. But most people would say the judiciary because of the enforcement of the laws, but they don't actually enforce laws. That's the executive. But yeah. And I love that Tom's in the chat because he does know a lot about this stuff. He is a very knowledgeable man, and it's kind of nice to be able to throw things off of him. All right. The next video is going to be talking about the federal judiciary. It's not actually going to be talking about the state judiciary, but the state judiciary system is pretty much set up just like the federal, but it's somewhat different. But here we go with Article 3 of the Constitution with the judiciary.
Constitution. Article 3 establishes the judicial branch of government, including the Supreme Court, whose job is to interpret the laws of the United States. To learn more about Article 3 in the judicial branch, I asked two experts to give me some more information. Jeff Rosen is the president and CEO of the National Constitution Center, and he's written extensively about the courts and the Supreme Court in particular. Richard Garnett is a professor of law and political science at the University of Notre Dame School of Law. Jeff, can you tell us a little bit about the framers' vision for the judicial branch? How much power did they intend for the judicial branch to have?
Well, let's start by reading the text. That's always the best place to start.
What happened, Mr. Zach? The judicial power of the United States shall be invested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. I loved how you stopped it right there and then. Like we said, each branch, the other two branches have a part in the judiciary branch. And Ronan, you are correct with that statement. We are supposed to be the most powerful branch of the government, but a lot of us have, and I will blame myself for this. I'm not going to blame anyone else. I'll blame myself. We let these cronies take over and tell us we're not as powerful as what we are. I agree with Callie.
I agree, Ronan. That's why the government fear us, because we have the amendment that protects us. That's why they are trying to destroy us by other ways.
They're trying to circumvent the Constitution of the United States. That's why me and Zach decided. I think that's why Zach decided to do these streams with me, because we can teach about what our Constitution actually tells us. But Ronan, very good observation, and yes, I agree with you. And Callie's right about that one. We have been duped. So I don't usually ask this on Zach's streams, but share these streams of the Constitution out with family and friends, because we need people to know about our constitutional rights. So please share these with your friends and family. I don't ask it very often, but when I do, it's an important thing because I want people to know this.
And the text of Article 3, the very first sentence says, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may, from time to time, establish. The framers expected that we would have a Supreme Court, and that would be separate from the legislature and the president, but it was up for Congress to decide what other federal courts we'd have, if any. And it's so interesting that the framers are so focused on a system where state courts are the main interaction that people have with the judicial system. They didn't even require Congress to set up inferior federal courts at all.
So what does Article 3 tell us about how the judicial branch is supposed to be structured?
Well, it doesn't say a whole lot. It's interesting. So some people are surprised when you actually read the text of Article 3. It sets up the Supreme Court, and it says that all of the federal judicial power is going to be in that Supreme Court, but it doesn't tell us anything about, say, courts of appeals or trial courts. It clearly envisions that Congress is going to create some, but it really did leave it to Congress to decide how to structure the judicial system.
So what are some of the ways that the role of the Supreme Court has changed over time?
Well, I think it's fair to say that there's a lot more federal law than there used to be, and so there are more questions that are potentially questions for the Supreme Court than there used to be. I mean, if you think of the country's early history, most of the legal action was in the states and the state courts and the state legislatures. There weren't that many questions for the Supreme Court to answer. As the federal government grows, as federal law expands, that creates more work for the Supreme Court. What does equal protection mean? What does due process mean? What's the balance between the freedom of speech on the one hand and intellectual property on the other, say? These are questions that the founders might not have been able to envision being judicial questions.
Alexander Hamilton in Federalist 78 famously said that the judiciary would be the least dangerous branch. because it had neither purse nor sword. The framers thought that Congress would be the most dangerous branch because it had the most enumerated powers. The presidency's second, limited but constrained powers, and the judiciary the least dangerous because it didn't have the army and it had no money, and all it could do was issue judgments and hope that they would be accepted by the other branches.
So say that I'm a Supreme Court justice. Good work, me. And a case comes before me, and it's up to me now to interpret the Constitution in such a way that I can answer questions about this certain case. So what would be some of the tools that I could use to help me in my interpretation?
Well, there's obviously deep and fascinating disagreements among people about how exactly courts should do that. But one place where you could start, and I think there'd be common ground here, is that all justices believe that it's important to ask, well, how has the Supreme Court answered questions like this in the past? So the first place you would look would be to the court's own precedents, right? Has the court answered questions like this before? And if so, what did the court say? Because there is a strong sense that, you know, the rule of law needs predictability and consistency. And so courts really do make an effort to have their rulings be consistent over time.
You might also be interested in empirical facts. What would be the effect of a particular decision on the country? You might also be interested in theories of natural law, which we talked about in discussing the Ninth Amendment. Are there, even if the right being asserted isn't written down in the Constitution, is there some case that it is rooted in the history and tradition of our law, and that it might come from sources like God or nature and not government? Generally, judges have been reluctant to enforce rights, natural rights, that don't have a positive foundation. A positive right is a right that's written down or codified in some explicit way. A natural right comes from God or nature. But in practice, most of the natural rights have tended to be codified in history or tradition and state constitutions or state laws. So those would be other places you'd look too. But what's really important for viewers to remember, and I want all of you guys to try to do this yourselves, try this yourselves at home, separate your constitutional conclusions from your political conclusions. When you're evaluating a law, don't ask, do I think that this form of, say, gun control regulation is a good or bad idea as a policy matter? Ask yourself, do I think the Second Amendment allows or prohibits it? And entertain the possibility that your constitutional conclusions might diverge from your political conclusions. You might think gun control is a good idea, but the Second Amendment prohibits it, or it's a bad idea, but the Constitution allows it. And that basic separation of political from constitutional conclusions is central to Hamilton's very theory of judicial review, because that's what stops judges from being policymakers in robes and ensures that they're preferring the will of the people expressed in the Constitution to those of the legislatures, which represent fallible policy views.
As we learn from early cases like Marbury versus Madison, and then even later cases like Brown versus Board of Education, the Supreme Court can render decisions that then no one enforces. So how has the Supreme Court avoided becoming kind of a moot point?
Yeah, there's a story, and it might be apocryphal, but it's a good story anyway, that President Andrew Jackson said after the Supreme Court issued an opinion that he didn't like. He said, well, the Supreme Court has issued its opinion, now let them enforce it. And basically making the point that all they could do was issue an opinion, and it was up to others to decide to comply. I think, you know, American culture, and this is something for us to be grateful for, it's been built up over a long time, has generally been that we have a strong norm that elected officials should follow the law as it's been declared by the federal courts. Now, there have been, as you know, controversies about court decisions throughout our history, whether it was the Dred Scott case, which President Lincoln hated, or, as you said, Brown versus Board, which was resisted by some Southern officials after it came down. The court's ability to get its judgments enforced depends on its credibility and on America's culture of respecting the rule of law. If the court's credibility goes away, or if Americans stop respecting the rule of law, then the court's judgments will have less force.
So the Supreme Court exercises the power of judicial review, which means that it reviews the actions of the executive branch and the legislative branch and can declare those actions unconstitutional. Do you think the framers intended for the court to use that power to check the other branches of government?
Most scholars would agree that it was widely believed that the Supreme Court would have the power to review the acts of both federal officials and of state governments, and to decide whether or not those acts were consistent with the Constitution. Now, there was a lot of disagreement about how excited people were about that power, and again, some people worried that the Supreme Court might abuse its power of judicial review. But the basic idea that it's one of the jobs of a court to make sure that the acts of other officials are constitutional, are consistent with the written Constitution, that idea pre-existed Marbury. That idea was clearly in the minds of the founders when they created the Supreme Court.
And I'm happy to say, yes, the framers did intend for the courts to have the power of judicial review. And I'm confident of that, both because the power was exercised by courts before and after the framing, and also because Alexander Hamilton in Federalist 78 so explicitly puts the case for judicial review. It's such a shame that in that great musical, we've got the room where it happened, but we don't have, the judicial review where it happened, because it would be a great song about why Hamilton thought that judicial review followed logically from the very theory of popular sovereignty.
It really isn't the job of unelected judges to try to update and improve the Constitution that the people ratified. In some cases, this isn't much of a challenge, but in others, say in cases having to do with the freedom of speech, or in cases having to do with the war powers and so on.
Hey, Zach, stop it for a minute.
To figure out what exactly the provision meant to those who ratified it, and it can be a challenge.
All right. I am going to ask this, and yes, I do know the answer to this. Can you legally go in a crowded theater and yell fire when there is no fire? Legally, can you do that? Yes or no?
Mm-mm.
I love this interaction in the chat. And go ahead, Zach.
Is that basically incriminating?
No. Because you can actually do it in a crowded theater, but like Rich Wells says, you can do it, but it's not recommended. Because if someone gets hurt, you are liable for that. You might not get charged criminally, but legally, you can actually yell fire in a crowded theater and not get a criminal charge. There was a reason. I'm with Ronan. I would not do it, but legally you can actually do that.
Whether, if at all, the original meaning needs to be updated in light of more current events.
Now, there's, of course, much to say in response to Hamilton, and we could have a whole constitutional law course on the responses to Hamilton. His very theory of judicial review is premised on the idea that the Constitution represents the will of the people more emblematically or profoundly or fundamentally than the ordinary laws. And the obvious first response is, hey, how can you say that the will of a bunch of dead white guys from 1787 really represents the will of we the people today more accurately than a law that Congress passes? And the answer to the objection is, well, it's because the Constitution was passed by a special procedure. It was unusually deliberative. It took a long time to propose, and it didn't gain the status of supreme law until it was ratified by special conventions that were specially called for the purpose. And it was that long process of deliberation that gives that constitutional text the right to speak in we the people's name.
How could the legislative or executive branch check the power of the Supreme Court?
Yeah, our Constitution has a number of these interesting checks and balances features, right? So the three branches are distinct, but there's various ways in which they get into each other's business, right? The president can veto a law. The president appoints justices, but of course the Senate has the say about whether to confirm them and so on. So the branches are separate, but they are related and they check each other.
Well, we remember from the text of Article 3 that the Constitution authorizes Congress to set up such inferior courts as it may from time to time choose to ordain and establish. Congress didn't have to create inferior courts. It can create them. It can change them. There's a debate right now about whether the Ninth U.S. Circuit Court of Appeals, which occupies much of the West, should be split up, and Congress can split it up if it wants. Congress can change the number of Supreme Court justices. There were originally 6 justices, and the number went up and down before settling around 9 settling at 9 in the 1860s. So Congress could change the number of justices to punish a president on political grounds. When Thomas Jefferson was coming in after the election of 1800, the outgoing Federalist Congress was so determined to punish him that they changed the size of the Supreme Court to deny him the right to make any appointments.
The other branches can check the court in a number of ways. So the most dramatic would be, you could impeach a justice for high crimes and misdemeanors. That doesn't happen very often. Another way, which doesn't happen all that often, but could, is Congress can check the court by, for example, not funding it, or by limiting the issues that the court is allowed to hear. Congress can control what's called the jurisdiction of the court. The court only gets to answer the questions that Congress gives it the power to answer. Now, again, Congress is reluctant to do that, but it has sometimes in the past, and it could if Congress thought it were necessary.
Congress can engage in jurisdiction stripping. There's only a small category of cases that the Supreme Court is required to hear, but broadly the court has a broad discretion over its docket. And if Congress wanted to say, hey, Supreme Court, you're not allowed to hear any cases involving abortion, for example, it arguably could do that, although such a law might be constitutionally challenged. I remember being in law school just kind of indignant at the idea that Congress could violate the separation of powers so flagrantly. My great law professor, ▏ convinced me that this had been done throughout American history, that before, during the Civil War, Congress deprived the court of the right to hear certain cases involving national security and so forth. So Congress can, if it chooses, exempt certain categories of cases, those that are not in the original jurisdiction of the court, from being heard. There's also the question of whether Congress could impose term limits for Supreme Court justices. And there's a proposal floating about to have 18-year terms for the justices and give each president the right to appoint 2 justices and have justices retire after 18-year terms. There's a vigorous debate about whether that could be done by an ordinary statute or whether it would require a constitutional amendment.
Well, if you had to say there was one big takeaway about Article 3 that students should remember, what might it be?
That when courts strike down laws as unconstitutional, they're not thwarting the will of the people. They're supposed to be supporting it, because the Constitution represents the will of the people. Ordinary laws represent the will of our representatives, and the Constitution is supreme law. So that's why it trumps ordinary legislation.
Americans of good faith and good reason have been disagreeing about the court's role for a long time. I think a challenge for the court is finding the right balance between asserting its independence and exercising judicial review on the one hand, but on the other, being mindful of the fact that it is undemocratic, that judicial review sometimes involves setting aside what the people have decided they want. And that's an awesome power, and it shouldn't be overused. So the court, from time to time in history, has been criticized for perhaps going beyond what the Constitution actually requires and instead enforcing perhaps their own policy preferences or their own political morality.
So we've learned that Article 3 is crucial to the system of checks and balances that limits the power of government in the United States. The Supreme Court exercises judicial review to ensure that the executive branch and legislative branch act within the confines of the Constitution, but the other branches have plenty of checks on the judicial branch as well. One of the most central questions about the Supreme Court is the relevance of the Constitution to the issues we face today. As Richard Garnett points out, some scholars might say it's undemocratic to overrule the will of the people as expressed through their elected representatives based on the Constitution. But as Jeff Rosen argues, the Constitution is the supreme law of the land, and therefore striking down a law as unconstitutional isn't thwarting the will of the people, but rather preserving it. To learn more about Article 3, visit the National Constitution Center's Interactive Constitution and Khan Academy's resources on U.S. government and politics.
Zach, what do you think of what we learned tonight? Because a lot of people, with judicial review, the judiciary, the Supreme Court, is actually supposed to look at every law Congress writes up. They're supposed to look at every single piece of legislation, but there have been activist judges, as we know that. So, with certain ones, they have not done that. But the Supreme Court does have the ability to strike down laws that are very unconstitutional. Because the Constitution, like it said in there, the Constitution is the supreme law of the land. It's supposed to be, but we got politicians that's been in there for a half a decade, a half a century, and they don't care.
See, we should enforce this because what they are doing today is totally ridiculous and tyrannical.
Very much so, Zach. Very much so. And put Hoodow's comment up, please. The thing about it, I'm not going to say this now. If you do not want that to happen, if you want to have a little say-so and what actually happens with judicial review, with nominees of the Supreme Court, please vote. Because if we vote people in that will actually listen to us in the Senate, guess what that means? They don't get it. That's And Ronan, actually, to some extent, the Supreme Court does have a say so if it's with states' rights, because, like in New York State, they have a law where people can't carry a firearm outside of their home, which the Supreme Court has taken up. That would be states' rights, but federal government says you can't do that. So there are limitations to what the Supreme Court can actually do, but if it goes against the Constitution, then they have to step in. Just like if there's a dispute between two states, the Supreme Court steps in. And are you ready to answer, Scotty? All right. But it's also a state issue.
Scotty, I have backup channels because I got struck a week ago today. I have a video on my channel that has links to the backups.
But yes, Ronan, 2A is a constitutional issue, but it's also a state issue. There's a lot of overlapping between state issue and federal issue, and that's what a lot of people get, why they get confused. Thank you, Getter, for putting Zach's second channel up. Lance, you're very Zach. What have you learned tonight with between the executive and the judicial branch? Because I can tell you're getting tired. So, are you good? All right. But if anyone has any questions on the previous streams we did, we would be more than willing to actually answer them, because we do. Scotty, you have no idea. But I will say this now. Before he did his stream a week ago yesterday, I warned him that it was going to happen. But he did a good show. Oh, and I will do this. We will go, give me 1 minute. And if a video is taken down off of YouTube, you can go here to Zach's Odyssey channel and get all the ones that they take down off of YouTube. So, and I made that myself for Zach, and he has complete control of it. So I am helping my friend out, and we are live streaming on that right now. So hello to all the people over on Odyssey, which there are 3 other people other than myself. But at some point, all all of Zach's streams that are on YouTube will be on Odyssey. We're in the process of doing that, so give us a little bit of time. Hi, Michelle.
I exposed that donkey-faced Dr. Scotty. I went deep down the rabbit hole. And I'm actually uploading videos to other platforms too.
We're making sure Zach's information gets out there to everybody. Silver Girl, I know that, but it is also a great backup tool for all of us. Odyssey, Rumble, I hope to get Zach on Rumble pretty soon.
I have Rumble too.
All right. But yes, we are trying to get Zach going good on all of them. Yeah, Rumble is doing a heck of a job. Because I actually do live stream over on Rumble and all that fun stuff. I do like Rumble.
I'm creating my own platform as well.
That's very true too, Zach. Because I know I can already tell you who the first two accounts are going to be. They're the two people up here right now. But yes, Zach is. Yes, please donate to our buddy Zach. Zach is doing a heck of a job, and Zach Shack. That's a heck of a name. Scotty has a heck of a name. That's a pretty good name. What you think, Zach? No?
It's called yoretube.
All right. That is cool. Ten times. Oh, for crying out. Hey, Zach, are we just egging Scotty on with this?
Yeah, I'm unfortunately behind because right now I'm building 8 mobile applications.
But as soon as he gets that up and running, we will probably be streaming a lot more over there than we are on this platform. But we will get. And Zach, you have my number now. If you need some help, let me know.
Any last words, Angry?
Just share this information out with friends and family so people know what the actual Constitution says. Because if we get more people to know what the Constitution says, I think more people would actually come to our side and fight to keep it the way it is and not actually try to circumvent it. But I want to thank you, Zach, for all you do. But that's my final words, my friend.
yoretube.net. YoReSpot.com is the Facebook alternative.
Oh, Scotty. Oh, for crying out loud. Zach, did you see what Scotty said? Oh, for crying out loud.
Well, hey family, thank you for coming and learning more about the Constitution. We need to keep fighting with knowledge because it's more of a tool than anything else. I love you all so much.
We need you now. We need you now. One day, one day, one day. Oh, one day, I hope you see the truth. This puppet show stays on because of you. We've been dancing with the devil way too long. I know it's fun, but get ready to pay your dues. Oh God, come back home. This crazy world is filled with liars and abusers. We need you now before we're too far gone. I hope one day they finally see the truth. God, we need you now.
Good night, everybody.